Welcome everyone to this new episode of the Privacy Rules Privacy Espresso series, a series where we interview our experts from all over the world on the latest news on privacy, technologies, and data protection, of course. One of the news that has been most recent, in particular in the late fall of 2023, was related to a new law coming from India, the so-called Data Protection and Privacy Act. So I'm very pleased today to have two of our experts from Kochhar Co, exclusive law firm member of the PrivacyRules Alliance for India, that are Arun Babu and Gayathri Poti from the firm and from their team on IP and TMT. So between the experts that deals on a daily basis with privacy and data protection. So first of all, Arun, Gayathri, thanks a lot for being with us today.
Thank you
Thanks
so
for
much, Alessandro, for having us here. Thank you.
It's our pleasure, and I would like to immediately start asking you some question on what's about the law and what's happening there. So maybe I can start with you, Arun. Can you provide us with a brief overview on what is the India Digital Personal Data Protection Act?
Sure, Alessandro. So the Digital Personal Data Protection Act was enacted as law last year in August. This is the fifth iteration of India's data privacy law. After the first version of the law was released way back in 2018. As of now, we expect the government to implement the law by end of this year. In terms of its applicability, the law applies to processing of all personal data maintained in digital form. So the law essentially has extraterritorial applicability. So in addition to processing within India, it also applies to processing of personal data outside India, where such processing is for offering goods and or services to data subjects within India. There are, however, certain blanket exceptions under the law. And then the law does not apply to certain processing scenarios. So the law does not apply to processing for domestic or personal purposes. The law does not apply to processing of publicly available data. The law does not apply to certain notified government agencies where they process personal data for national security purposes. The law also does not apply to processing for research, archiving, or statistical purposes. So there are these blanket exemptions under the law to which the law does not apply at all. Unless there's an exemption under the law, you'll need a lawful ground under the law to process personal data for any purpose. Now, unfortunately, consent is the only lawful ground under the law. The law does not include other commonly known lawful grounds such as legitimate purpose or contractual necessity. So, that is one drawback with the law, and consent is the only or consent is the main lawful ground under the law. The consent standards under the law are fairly high. And for consent to be valid under the law, it must be free, specific, informed, unconditional, unambiguous, and expressed by an affirmative action. But of course, there are certain grounds under the prescribed under the law which enables processing without consent. These are termed as legitimate uses of personal data. So now, a legitimate examples of legitimate uses of personal data can be processing for employment purposes, or where an employer processes personal data to prevent loss or liability to itself, processing for medical emergencies, processing for disaster management, processing in furtherance of exercise of state functions. All these are considered legitimate uses of personal data, and for these purposes, consent is not required. There are certain rights under the law. These rights are typically included. I mean, you'll see these rights in most global data privacy legislations. So these are, right to confirm what data is being processed, right to correction, updation, deletion, and erasure of personal data, right to grievance redressal, etc. There are no data localization restrictions under the law. The previous versions of the law did have data localization restrictions. The DPDPA does not include restrictions on transfer of personal data. But having said that, the law empowers the government to come out of the blacklist of countries to which transfer of personal data would be restricted. Interestingly, none of the compliance requirements under the law applies to data processors, and all the requirements applies to data controllers. And the data controller is obligated to ensure the processor's compliance with the law. The penalties under the law are quite steep and can go up to INR, Indian rupees 2.5 billion, which roughly translates to 30 million US dollars. Now, to conclude, the law we believe is a good first step. Considering that India has had very minimal data privacy laws, and considering that as a society we have very low privacy standards. The law is principle based, and unlike many other Indian laws, it's concise and written in very simple language. Right. So these are quite a few disadvantages with the law, but of course the law does lack in certain aspects. Like I mentioned, the fact that there's no alternate lawful ground for processing, I think, is a big drawback given the high standards for consent, right? So it may not be possible to obtain valid consent in every processing scenario. So, we'll have to see how all of this will unfold once the law is implemented.
Of course, and thanks a lot for this very brief but very well done introduction to your law. I remember that there have been a lot of drawbacks, in different proposal in India. Probably one of the key problem is that using GDPR as a model was too strict for a country where privacy was not that developed at that time. But I think it's as you are rightly saying, a positive fact that there is a first step, and there are already interesting parts in this law that perceive and structure privacy protection and data protection. In this regard, I could hear a lot of similarities, but also differences with GDPR. So following your advice, maybe with Gayathri, we can go through that to learn a bit more of those differences and similarities.
So firstly, with regard to the applicability of the law, the GDPR applies to both digital and non-digital personal data, whereas the DPDPA only applies to digital personal data and therefore excludes the manual processing of personal data. Secondly, in terms of the lawful basis for processing, both the GDPR and the DPDPA have certain similarities. But so, for example, both laws permit processing on the basis of consent, processing that is necessary to fulfill a legal obligation, or processing that's necessary for a medical emergency. However, there are some grounds for processing that are present in the GDPR which are absent in the DPDPA and vice versa. So, for example, the DPDPA, unlike the GDPR, does not recognize legitimate interest as a grounds to process personal data. But the DPDPA does permit processing of personal data for employment purposes, which is not a ground that is recognized under the GDPR. Thirdly, regarding the breach notifications, again, this is one of those areas where the DPDPA might perhaps be more stringent than the GDPR, because the GDPR requires a personal data breach to be reported only if the breach poses a risk to the rights and freedoms of individuals, and that breach has to be reported to the data subject only if the risk is high. But the DPDPA, on the other hand, requires data controllers to report all personal data breaches to both the Data Protection Board of India and the affected data subject, irrespective of the severity of the breach. The timelines regarding the breach notification are yet to be issued by the government, so we aren't clear on that aspect yet. Then regarding the fourth difference, which is the rights that are granted to data subjects. Now, the GDPR grants a much more comprehensive set of rights, whereas the DPDPA grants a more limited set of rights. So, for example, under the DPDPA, you don't have the right to data portability, you don't have the right to object to the processing of your personal data, or the right not to be subject to automated decision making. However, you do have access rights, right to erase personal data, right to rectify your personal data, and right to grievance redressal. And also under the DPDPA, the data subject rights are only granted to those data subjects whose personal data is processed on the basis of consent, or if they've voluntarily provided that personal data. And these rights are not available under all circumstances. And lastly, the difference that I wanted to cover was with regard to data processors, which Arun has already touched upon. So basically, the GDPR has individual independent obligations that are placed on data processors. So a data processor under the GDPR is expected to implement adequate technical and organizational measures. They're expected to appoint a data protection officer if applicable, and also report personal data breaches. However, the DPDPA actually does not impose any obligations directly on the data processor. Rather, it is the data controller who is responsible for the data processor's compliance with the law. So it's very likely that if a data processor violates the DPDPA, it is a data controller who will be held responsible. So That's broadly most of the differences. Yeah.
Thanks a lot, Gayathri. That was very interesting. Thanks for the comparison. That always helps because we are all used, unfortunately, to GDPR. So it's always good to understand, which are the differences. And I think this brings us to our next question, meaning that in terms of practical steps to be taken, both for companies that are already GDPR compliant or not in India, but as Arun was saying, this law works also, out of the territory of India. So maybe, Arun, what measures should company take to be compliant or to start complying with DPDPA?
See, unfortunately, the law heavily relies on delegated legislation. So the government is empowered to notify rules in respect of 26 matters, right? So a huge part as to how the law will be implemented and what organizations need to do to comply with the law would be covered under the rules that the government will notify. So we expect the government to notify the rules in the next couple of months or so, right? So in that ways, it may not be possible for organizations to, take comprehensive or conclusive measures to start complying with the law. But having said that, a lot of detail is out there in the law. So a practical first measure organizations could take is to do a data mapping exercise, right? To understand what personal data you hold, how long you have been holding it, the purposes for which you're processing it, where you're holding it, etc. Right, and then once you understand the purposes for processing, you'll need to evaluate whether you need to take consent under the law or whether you're processing it based on a legitimate use under the law. Say, for example, employers processing employee personal data for employment purposes do not need consent, right? But and they have the legitimate use exception under the law. So now, if you need to obtain consent, you'll need to design consent requisition forms. You'll have to draft privacy notices, etc. So you could start with these steps. The law requires implementation of reasonable security safeguards to prevent breach of personal data held by a data controller. So, therefore, organizations can start looking at industry standards and then and start implementing data security measures which are considered industry best practices. There are certain, I think I've already touched upon this, there are certain compliance requirements for appointing data processors. So essentially, a data controller can only appoint a data processor pursuant to a data processor agreement. So we've never had this requirement in India. So this is something that organizations would have to start doing from scratch. And another important, first step you could take would be to start having awareness sessions on the law. Again, I go back to my point where India has had very minimal privacy laws, and privacy awareness in India, could be on the lower side. So it makes a lot of sense to start, doing these awareness sessions for your employees, suppliers, vendors, so forth and so on, so that they're aware of the law and they're aware of the requirements under the law. Now, of course, if you're a GDPR compliant organization, you've already done at least part of this. But there are certain unique requirements of the DPDPA, like both of us mentioned, attainment of consent, right? So, there could be a scenario wherein you can process data for certain purposes under the legitimate interest lawful ground in Europe. But since this lawful ground is not available in India, you may have to obtain consent. So therefore, you would have to evaluate the purposes for which you're processing personal data in India, and you may need to take consent and then comply with the related requirements for obtaining consent. So that's just one example. The point here is that there could be requirements which are specific to the DPDPA, which you need to watch out for and start complying with.
Absolutely, Arun. Thanks a lot, in particular, for warning our listeners of the differences that there might be in complying. Even if GDPR is a high standard, doesn't mean that by complying with it you comply everywhere in the world. And I think you touched very good points in relation to the legitimate interest as a legal basis that is pretty much used in the EU and for the EU. But if not available there, that's something companies should be aware of and immediately check for solutions to this problem, and doing it, of course, with experts locally based, as you are, that knows the laws and all their intricacies. We have heard of many of them, so thanks a lot for make us all aware of these today. We are running out of our time, so I would like to thank you for being with us and for your time, for your clear explanation. And of course, I would like also to thank our listeners for being with us today. Looking forward to our next Privacy Espresso together. Bye, Arun. Bye, Gayathri.
You're welcome, Alessandro. Bye-bye.